Hi everybody, myself Sofiya, Assistant Professor, School of Law, Satyabama Institute of Science and Technology, deemed to be University, Chennai, Tamil Nadu. The topic for today's session is Quasi Contract. So let us all see what is Quasi Contract and how it differs from contract. As we all know that for a valid contract there should be an agreement, and that agreement should be in writing or it may be in oral. But when it comes to quasi contract, there will not be any agreement, but there will be an obligation to the party to fulfill. Quasi contract is not at all a contract, but it is similar like contract. So when I say this person looks similar like you, does it mean that the person who I am referring is you? No. So it means that there is a similarity between you both. Likewise, the quasi contract is not a contract, but it is like a contract, but it is not a contract. And the word quasi refers to similar or just like. And the parties to the contract will not have any intention of getting into this kind of contract. Even the parties do not make this contract. Then who creates this kind of contract? This kind of contract is created by the creation of law. Even the responsibility to the parties is imposed by the creation of law. So as we all know that for a valid contract there should be a right as well as there should be a liability. But when it comes to quasi contract, there will not be any right to the parties, but there will be an obligation to perform the contract. The quasi contract is mainly based upon the equity principle. What does equity principle says? The equity principle says that everyone is equal and it gives equal footage to all the parties. That is the reason why the wagering contracts and the betting contracts are not permitted by law. Because if I win, I become rich at the expense of somebody's expense. So that is the reason why wagering contracts are not permitted, because for a valid contract, as we all know that both the parties should be a beneficiary party. One should give and one should get. But when it comes to wagering contracts, this rule is not applicable. So that is the reason why the law is not permitting wagering contract and betting contract. But the law does not want one party to become rich at the expense of or at the cost of someone's expense. So this principle is based upon the unjust enrichment. For example, you found a wallet from a public place and the wallet contains 10,000 in it. Now you become rich by 10,000. See, the moment you pick the wallet, it tells through the quasi contract that now you are under a contract and now you have the responsibility to take care of the wallet and you have to return the same to the original owner. And you are not supposed to spend the cash of 10,000. And this is what the principle of equity is all about. It says that no man can enrich himself at the expense of somebody. So there are 5 types of quasi contract. Section 68 to 72 of the Indian Contract Act says about quasi contract. Now let me read out section 68 of the Indian Contract Act. Section 68 of the Indian Contract Act 1872, claim for necessaries supplied to person incapable of contracting or on his account. If a person incapable of entering into an account or anyone whom is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Section 68 of the Indian Contract Act gives liberty to the person who supplies necessary goods to the incapable person. Before eye of law, who is incapable person? The one who is not competent to contract. Lunatic person is not competent to contract. Minor person is not competent to contract. Insolvent is not competent to contract. And at the same time, insane person is not competent to contract. So these persons are incapable of getting into contract. So if a person supplies any necessary goods to incapable person, he can get back the amount from the property of the insane person, or he can get back the expense which he has spent for the incapable person. For example, if he supplies a luxury goods to the incapable person, but he will not get any remedy before the law to get back his money. That is what section 68 says. Section 68 gives a liberty to the person who provides a necessary goods to the incapable person. So section 69 of the Indian Contract Act says that reimbursement of person paying money due by another, in payment of which he is interested. A person who is interested in the payment of money which another is bound by law to pay and who pays it is entitled to be reimbursed by the another. So section 69 of the Indian Contract says that if an interested party pays on behalf of the person who is legally bound to pay, he can get back the amount which he has paid for the legally bound party. Like, for example, A is letting out his premises to B and he is fixing the rent of rupees 10,000 per month. Now A is supposed to pay rupees 5 lakh to the corporation, municipal corporation, which is due by A. Now B makes payment on behalf of A. Now B can get reimbursement from A because A is legally bound to pay the corporation. So according to section 69 of the Indian Contract Act, the interested party who pays for it on behalf of the legally bound party, he can get back the money which he has spent for him. So now let us see section 70 of the Indian Contract Act. Let me read out section 70 of the Indian Contract Act. Obligation of person enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit therefore, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Section 70 of the Indian Contract says that if the act is not a gratuitous act, the person who enjoyed the benefit should return the same to the one who spent for it. So if the intention is not gratuitous, he is supposed to and he is liable to return the same to the one who spent for it. For example, A is saving B's house from fire. Now A is claiming towards B for saving the house of B. This act seems to be a gratuitous act at the instance. So such kind of relief cannot be given by court because this kind of act seems to be gratuitous act. But when the act is very clear that it is not a gratuitous act, the person who enjoyed the benefit should return back the same to the one who spent for it. Now let us see section 71 of the Indian Contract Act. Let me read out section 71 of the Indian Contract Act. Section 71 of the Indian Contract Act 1872 says about the responsibility of finder of goods. A person who finds goods belongs to another and takes them into his custody is subject to the same responsibility as a bailee. Section 71 of the Indian Contract Act gives a responsibility to the finder of goods. What is finder of goods? Who is called as finder? The one who finds the goods of another is called as finder. The moment he finds the goods of another, he gets some responsibility by law, and the liability is imposed by law. What is the liability before law? He has to return the same in the same condition. He has to take care of the goods and he is not supposed to mix the goods with his own goods, and he is not supposed to use the goods. He has to take a reasonable care towards the goods. And these are all the duties of the finder of goods. So the moment he finds the goods of another, he can hold the custody of the goods. He has to retain the custody of the goods until the true owner claims for it. And he should try to trace out the true owner. And if he could not trace out the true owner, then he can sell the goods. Or if the goods are perishable in nature, on that situation he can sell the goods. Otherwise he is not sell the goods which belongs to someone. So the responsibility of finder of goods is that according to section 71 of the Indian Contract Act 1872 says that the person who finds the goods cannot take it for granted. He should return the same to the one who lost the goods, and he has to show a reasonable care towards the goods. So section 71 gives a responsibility and it imposes the responsibility to the finder of goods. Now let us see section 72 of the Indian Contract Act. Liability of person to whom money is paid or thing delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. So section 72 of the Indian Contract Act says that it's a responsibility and it is the liability of the person who receives the money under a mistake or under any coercion. He has to return the same to the one who made payment by mistake. It is not that he can take it for granted. It is not that he can use the goods which has been delivered by mistake. So he is under a responsibility. The quasi contract automatically tells him that he is under a responsibility. He has to return the same to the one who delivers the goods by mistake. For example, if a trader by mistake delivers something to B, now B is under a responsibility that he has to take care of the goods or he has to return the goods to the trader. It is not that he can enjoy the goods. So although knowing that it is by mistake or it is under coercion, he cannot retain the goods, stating that the transaction is by mistake. So he is also having a responsibility to return the goods. At the same time, the trader is also having the right to claim for the goods which he has delivered by mistake. I hope you all understood the concept of quasi contract. Section 68 to 72 of the Indian Contract Act gives a liberty to the parties to such kind of contract. In India, the quasi contract is strictly followed because we follow the equitable principle. I hope you all understood the topic of quasi contract. Next session, I'll see you all with some other topic. Thank you.